Welcome, everybody. I can figure out how to get it on. I'm John Haig. I am the co-director of the Mosavar Rahmani Center for Business and Government. It's great seeing so many of you here. I'm going to introduce briefly, we have John Salat here with us. As usual, John's really been one of the leaders in helping us with our tech and regulation kind of activities. Nancy Rose as well. Not a lot of background on either one of them. John is heavily engaged in the Google antitrust lawsuit and is currently the Special Assistant Attorney General for the state of Colorado. He is also a visiting, he's a senior fellow, senior research fellow here at the center. So I'm going to turn it over to him, and we're fortunate today we have Fiona Scott Morton with us, and the topic is on the board, the DMA. I assume if you're here, you kind of know what DMA stands for. But just in case, it's the Digital Markets Act. John, it's all yours.
Thank you, John. Is this microphone working? That's always the most important first question a speaker can ask. Let me say a few words about Fiona. Let's start this way. Physicists tell us there are 4 elemental forces of nature, like gravity. Gravity is important. Physicists think there are 4 because they haven't yet met Fiona Scott Morton, okay, who is a force of nature. Let me just tick off. Professor of economics at Yale, former Deputy Assistant Attorney General for Economics at the Antitrust Division at the Department of Justice, founder of the Thurman Arnold Project at Yale, which helps students engage in antitrust research, leader of the Yale Tobin Center's project on digital economy. Impressive in every way. But I want to say, as I always have to, these are my personal views as an antitrust enforcer. But as an antitrust enforcer, I want to emphasize Fiona's importance to the aggressive and focused enforcement of antitrust law and the pursuit of competition more generally. It goes like this. To extend the metaphor, monopoly that harms competition can be an unmovable object. It's really big and it's disinclined to change its position. So the job of antitrust enforcers is to build the irresistible force. And in many ways, Fiona has made that possible. It's a big task, right? Because I will tell you, litigating against monopoly is complicated. Evidence, instructions, law, economics. And what Fiona has done is work hard to bring smart economics to forceful antitrust enforcement. And I will tell you that makes a difference. She's made a difference as an expert witness, as an organizer and leader of antitrust thinking, bringing other people into the game to help create knowledge that's useful. More recently, in a series of articles offering practical advice to antitrust enforcers about how to think about pending antitrust issues. And I want to say, offering very useful ways for enforcers to understand better the challenges they face and how to overcome them. But as the big slide tells us behind me, antitrust enforcement is just one aspect of the protection of competition. The DMA, in effect in March, is now taking center stage in global digital regulation. And in concert with that, Fiona has turned her attention to Europe. Fiona expressed an interest in serving as chief economist for DG Comp, right, the European-wide competition law enforcer. Europe, in my view, unwisely declined to accept Fiona's offer. And it says a lot for Fiona that she kept going. She joined the Bruegel, which is the leading economic think tank in Europe. She's joined Bruegel, dealing with competition issues, writing a series of recent papers on how to best confront the enforcement challenges that EU faces now that the DMA is in effect. It's a big experiment. We're fortunate to have Fiona here today to share her thoughts on what it means, what it stands for, and what can be done best to effectuate its goals. Fiona, thank you.
John, for that extremely kind introduction. I'll say that it is. I mean, what John said was too generous, but it certainly is a goal of mine to do those things that he described. And for those of you who are thinking about engaging in that enterprise, also, it's really important to stay ahead of what the regulators need. So, for instance, in 2020, David Dinelli and I wrote roadmaps for how to bring antitrust litigation in the Google ad tech case, Google search, and Facebook. And in 2018, John Baker and I wrote a paper about how to bring an MFN case against Amazon. And those things duly happened. Let's not go into causality, but once you've understood what the interesting intellectual challenges are in those cases and written it down, then there's not much else to do from the outside. You're in your office, so you have to move on to something else, and this was the next thing, and that got leaked actually the first draft in the fall of 2020. So I've been following the DMA now for several years. Both thinking about its design and then thinking about the platform designations, which happened last September, and then enforcement, which is now fully in place as of March. Um, so why did we get to the DMA? Well, we have characteristics of the digital economy, which all of you know, network effects in particular, and a positive feedback between quality, usage, data, quality, usage, data, and zero marginal cost. There's also really important aspects of behavioral economics that show up in digital, and that's lab and field evidence show us that consumers are not the neoclassical consumers of the old days. We can look at 40 years of behavioral economics, multiple Nobel Prizes to know this. So this is, I'm not telling you anything you don't already know, but what this means is that consumers have all these biases. The platform has control the choice environment. They have millions and billions of users visiting a page every day and can engage in A/B testing to figure out whether you're going to be more likely to click on the red button or the blue button or the font that's big or the font that's small and so forth. So what that means is that our choices are not as free as they look, and we're steered online to the place that the platform wants us to go. So that alters some of the ways we think about these markets. So the result of those two, that characteristic slide and the behavioral economic slide, is that we end in this place, which is competition is unlikely to arise in these new economy markets because competition has moved from competition in the market to competition for the market. That is to say, we have MySpace and Facebook battling it out, and then Facebook wins, and then we basically have a monopoly in personal social networking services. And to the extent we had competition, it was in that stage one, but once we get to stage two, we're done, and the network effects are so strong that you have entrenched market power, and you don't have much competition in the market anymore. And that would be true even if no one had violated any antitrust law. Okay, but the problem is the competition for the market is inefficient. Why is it inefficient? When is the new rival going to come along? Consumers have switching costs, which they have to pay if they're going to move. They all want to move together, so there's a coordination problem. How do the consumers figure out when to go? Meanwhile, the entrenched incumbent has a really easy time defeating competition for the market because there's nascent or potential entrants that they can buy or bury at an early stage before the regulator realizes that they're potential entrants. They understand what's a substitute and what's a complement much better. They have ability to strategically use interoperability with the existing platform, and they have a large amount of market power that they can wield in all these dimensions. Therefore, policing competition for the market is nearly impossible for a normal antitrust authority with a limited budget and asymmetric information. So we're just really not in a good place here. It's not going to work out well for consumers. So what do we do? Well, there's three policies that we can use to help: competition enforcement, regulation, and consumer protection. I'm today going to, one of my slides is missing. Anyway, today I'm going to focus on number two, which is regulation. Yeah, okay. So why do I go straight there? It's because We have in the United States not done a great job until the last 3 years or so with our competition enforcement of digital platforms. But Europe actually started the first Google investigation in 2010. So they've been at it for 13 years and 14 years. And even though they started in 2010, not until 2023 was there basically an acceptable choice screen offered by Google as a remedy for the conduct that was first initially investigated in 2010. So that's just way too long to be helpful. And even an average antitrust case takes 7 years in Europe. In a digital market, that's an unacceptable amount of time because you've moved on to the next technology basically by then, and so you haven't restored competition. There isn't a useful remedy at that point. Whatever it was you found that was wrong is long gone, and so the result is that the Europeans said this antitrust tool is not working to get us the answers we want, the results we want. We're going to move to a different tool, which is regulation. So that was the slide I was looking for. Okay. Um, so I call it the failure of antitrust enforcement. That draws some eyebrows often, but I would say failure not in the sense that they didn't do it or that they didn't win, but just that it did not deliver competition in digital markets. So in that sense, it failed. And the correct response of a democracy is to say, right, well, let's make a different tool that gets us the result that we actually want. And here, that's sectoral regulation, where we're going to regulate only very large digital platforms. And the goals of the Digital Markets Act are contestability and fairness. What does that mean? Contestability is lower entry barriers, the ability to enter, ideally also entry. So that's the contestability piece, and then the fairness piece is let's evaluate where the rents are going and make the rents to all of these businesses accrue more evenly across business users, consumers, and platforms rather than the current arrangement, which is mostly giving them to platforms. The law is clever in several ways. It's not price regulation or technical specification other than messaging interoperability. It is about the definition and location of mandatory interfaces. And I'll go into that in more detail. And that interface is going to promote competition on the platform. So rather than competition for the platform, we're going to take that as that's water under the bridge. We've got one or two, and we're going to try to put the competition on top of those platforms. The law, because of this interface thing, lowers entry barriers, which promotes contestability, imposes more symmetry of outside options and bargaining power, so that allows the business user to take more of the surplus, and also allows the business user to grow more easily, which both helps with fairness and also helps with contestability in the sense of the next platform or possibly a substitute to the current platform coming out of a business user growing in some direction that's pro-competitive. Okay, what are the constraints? Well, it's tricky to write a regulation like this, obviously. And when I first saw it, I thought, I'm going to find a big mistake. It's going to be easy to find something really, really glaring. And in fact, it's not. In my view, I'd be happy to have other opinions on that. But there's a number of problems. You've got to fix the lack of innovation by gatekeepers. The big problem here is innovation as well as distribution of rents. And there's innovation by gatekeepers because they have entrenched market power. And then there's lack of innovation by business users because they don't want to innovate if they're going to be expropriated in the future. But then you have to also not unduly constrain the innovation of those parties. You're trying to enable it by stopping them from doing certain things, but not hopefully restraining the innovation as a result. You want to then distribute rents more fairly, and this comes up because the network effects mean that too much of the pie goes to the gatekeeper, and that feeds back into the innovation problem above. All the rents go to the gatekeeper, they then don't want to change anything, and the business users don't want to invest. You also have the very practical problem that the gatekeepers have almost unlimited resources, and so they can challenge anything. They can make litigation last forever. They can have 100 economists working on something when the enforcer has one. There's asymmetric information. The gatekeeper knows much, much more about the technology. They know what they can reveal some things and not. They can alter subtle things about the way we make choices or the way the interoperability occurs to defeat the goals of the regulator. And the pace of technological change is quick, so the DMA could be out of date very fast. And if the law tries to regulate too early, it could be wrong and choose the wrong thing to regulate. So that's all kind of a daunting list. Here's how they're handling most these issues. So the lack of innovation is going to be fixed by defining an interface to which the business user has a right of access and a right not to be discriminated against and a right to have the same technological functionality as the gatekeeper has on that same interface. What that means is the business user can innovate without being cut off or directed by the platform. If the direction of innovation is a direction the platform doesn't like, too bad, they can't discriminate against that business user or cut them off. And the business user can grow into a future rival of the platform itself, which is a major way we would expect entry in this world. There's no restriction, however, on what the business user can do. They just have a right to this platform. And there's no restriction on innovation above the platform by the business user or below above the interface by the business user or below the interface by the platform. The interface is the thing that is being controlled. And there's no restriction of the gatekeeper in entering into another core platform service. If Amazon wants to make a phone, or Google wants to make a better search engine, or Apple wants to make a search engine, all of that's fine. The rents get distributed in the following way. The law creates a bunch of methods to disintermediate the gatekeeper, which gives the business user a much better outside option. And with that better outside option, they can either use it or they can use it to press the gatekeeper to be more equitable in the rents. And the certainty of access to the platform increases the business user's willingness to invest. And this is something that's really important. If the access to end users only occurs through the platform and you don't control that, no venture capitalist wants to invest in you because you can just be cut off there's no way that you have certainty about being able to sell a product. And so regardless of the terms, the certainty of whatever those terms are is a really important element. The unlimited resources caused a couple of features of the law. One is that gatekeepers are defined by size, and this prevents years of litigation over whether they've got market power, whether they're a two-sided market, or any number of other issues that could be brought forward. It's just, do you have this many users? Boom, we're done. And there's a bunch of time limits specified in the law. The regulator has to do something within 6 months, and the platforms have to do something within the next 6 months. And it's very prescriptive in terms of timing, which I think is very healthy. Now, the asymmetric information and the ability of the gatekeepers being the information and ability being so asymmetric as between the gatekeeper and the regulator is the giant problem. And the way that the law deals with this is the gatekeeper is responsible for complying with the rule in a way that is effective at increasing contestability and fairness. So it's not the letter of the law, it's the spirit of the law. You have to be in compliance with the letter of the law, but if your letter of the law causes no one to actually switch or nobody to be able to enter, then there's an open question about whether you have complied with the spirit of the law. And so the gatekeepers, of course, very down on this. They're saying we can do everything, and because we're in full compliance, but our product is marvelous, no one will want to enter because nobody wants the rival's product. They all want our product. And that's, of course, a perfectly reasonable position to take. You want to have that right, but it's a giant red flag for the regulator if you're claiming compliance, but no business user is taking advantage of their new right to get on the platform. And that's where the regulator is going to focus attention, talk to the business users, and basically your legal requirement is that you have to do this in an effective manner. And if nobody can use it, it might not be effective. Furthermore, the burden of so showing falls on the platform. The platform has to turn in a compliance report explaining why the thing they did is increasing contestability and fairness. So it is not up to the regulator to show anything or to design anything. And that's extremely important. The pace of technological change is fast. The DMA has in it a provision to self-update. to do minor self-updates, and then to do market investigations that lead to major self-updates. And last, the platform, as currently anyway, is not regulating anything very new. The iPhone's 2007, Facebook's older than that, Google Search is older than that. These are all pretty old platforms that we have a decent understanding of. So I'm not too worried about that. For instance, AI is not in the Digital Markets Act, neither is cloud at the present moment. Okay, this is what it looks like. Gatekeepers are down the side. I'm not going to ever talk about ByteDance today. Core platform services are in the middle. The core platform service is the entity that must comply with the regulation. So there are corporations, and the corporations can have more than one core platform service, as you can see by the color coding here. I would say the category that's a little confusing is intermediation, because there's several things in here. One is e-commerce, Meta Marketplace, Amazon Marketplace, Google Shopping. The other is app stores, Google Play and the Apple App Store. And then the third kind of random one is Google Maps. Okay, the others are fairly self-explanatory. Here we've got Facebook and Instagram owned by the same firm. Video is only YouTube. TikTok is in the social networking category, which is an interesting choice. Ads, we know that Google and Meta have most of the display ads in the economy, except Amazon's growing fast and has the e-commerce ones. Operating systems, the ones we're going to be interested in, especially are Google and Apple, and then the browsers that are owned by the operating systems, and therefore the default are Chrome and Safari. Okay. Here is a very succinct one-page description of all the articles. If you haven't yet read the Digital Markets Act, I would encourage you to do that. The part that's crisp is Articles 5 and 6, which are just a list of all of these things that firms have to do. The recitals are quite interesting. It's a good read, and it's not that long. So if you're interested in digital platforms or regulation, I would recommend it. But 5 and 6 are the heart of the obligations and the prohibitions. How did these fall? We've got a bunch that are really, and I'll go into detail in a minute on some of them. We've got a bunch of restrictions on data. Some of these restrictions on data, like a ban on data combinations and data silos, are duplicates of the GDPR, but GDPR is still not being enforced in Europe because the large platforms, in particular Meta, have located themselves in Ireland and essentially captured the Irish Data Protection Authority, which has been acting on behalf of Meta and slowed down everything. And so we had to go all the way up to the General Court, the European Court of Justice, and then Meta responds with something that's completely not responsive, and then so we're going to have to go back up again. So that's a many-year project, and what the lesson from that was: don't let the member states do it. Put it at the European Commission level. These commercial relations are quite important. They're, I think, pretty obvious in the sense of when you have a gag clause and you don't let your developer tell the end user something, that's usually a red flag that you're not competing on the merits. I mean, if your product was really great, you wouldn't mind if people knew about other products. So this is, I think, a pretty self-explanatory group here. The mobile ecosystems piece, the most interesting one and important one, is sideloading. Sideloading is required under the DMA. And then we have very, very important, I think perhaps the most important provision in the DMA. Well, there's lots. So one of my favorites is 6.7, which is interoperability on the operating system, on the regulated core platform service. Any feature of that OS that is used by the platform itself has to be available to the business user at no charge. And then advertising, there's not much that is in here about the ad tech stack, except a lot of transparency and the requirement that the platforms provide analytical tools. So you're being charged the monopoly price, and under the DMA, you're just going to be aware that you're being charged the monopoly price, but not much else. And then there are two provisions that require FRAND pricing. One is click and query data, and the other is access to app stores. And then search results have to be unbiased and no self-preferencing, and that would, I think, mostly be relevant for search engines and then results on, say, e-commerce sites. Okay, so what exciting things could the DMA do? Let's try to envision the new equilibrium if it all works the way it's supposed to work. So the first thing is contestability in app stores. There's an explicit provision, 6.4, that says you got to allow app stores. So side loading of apps and allowing third-party app stores is mandatory. What else is relevant for these app stores? Well, they have to have under 6.7 equivalent functionality because they're a piece of software sitting on the operating system, just like Apple's App Store. So we got to have equivalent functionality. There has to be a way to get these apps that is not through the existing app store. So we need to be able to get rival app stores from the web or someplace like that, possibly through the well, the platform is in charge of deciding how they'd like us to find these app stores. And then the apps in the app stores cannot be restricted in what they do in either on the web or in the third-party app store with regard to pricing through an MFN clause, with regard to steering the apps like Spotify we're allowed to open up our Spotify app and be steered to the web to subscribe, for example. We're allowed to subscribe and pay on the web and then read or consume the content inside the operating system. So that's just disintermediating. Instead of buying it through the app store, I'm going to be told, click here, go out, purchase, come back, log in with your credentials, and consume the content. So that lets the app just completely avoid paying any of the fees of the platform. Banning the gag clause means that the platform can no longer say to Spotify, you may not tell readers or users that they can buy for less outside. So Spotify could say, you can pay here for 13 euros, or you can pay on the web for 10 euros. Up to you, we don't mind. And the reason it's more expensive is because Apple takes 30%. And so that's why we have to charge you more. And if the entry and contestability in app stores were to fail to work, we have the friend access conditions to the core platform service app stores, which are Google and Apple's app stores. So they would then be required to justify that the 30% was fair, reasonable, and non-discriminatory, for example. What does this do? I mean, it's the only app stores of interest here are the Google and Apple ones because we have a duopoly in mobile operating systems. Google has historically allowed rival app stores, but as we learned from the Epic case, Google has paid developers not to use those app stores, has limited the functionality of those app stores, and it's required those app stores to be on second and third pages of the home screen rather than right at the front. So those kinds of things no longer are going to be allowed because that's self-preferencing and not giving the same functionality to the rival. And I think a contract that says don't use the other app store, I'm not sure if the DMA has anything to say about that, but it probably does because it's obviously not promoting contestability. Apple has never had a rival app store. It's been vertically integrated from the beginning. So this is all new for Apple, allowing third-party app stores. What could happen? Well, I think from the developers who are who are paying in the current app store almost exclusively games and dating apps. Okay, and so these are not your most friendly plaintiffs. I mean, Epic sued, but I think many grown-ups out there, as we all know in the United States, the people who make decisions are almost invariably over the age of 60 and sometimes 80, and they're not the modal user of the product, so they're not thinking that they care much about gaming. But the gaming people do care because they're spending 30% of their revenue on the App Store. So developers are going to be able to stop paying. They're going to be able to send people out to the web. That, however, is going to work a lot better for games that belong to entities you trust. You've heard of Epic. You've heard of Microsoft. You've heard of Spotify. If I'm no-name game developer and I say, oh, click out to the web and give me your credit card, you're maybe not going to be too enthusiastic about that. So we're going to want third-party app stores to enter and be an intermediary in some sense between you and the game that you don't know very well, and make you feel comfortable that you're only going to pay 99 cents for it. So as I said, the developers can't have an outside option to steer you out to a website, possibly a website run by a trustworthy party that can take the money and that can charge a lower price, and then you can consume inside the app. I think we will see stores entering that have equivalent functionality under 6.7. They're going to compete on price, which the gaming people want, so that you don't have to link out. You can have all the functionality of having it right on the phone. I think we will get, if Apple allows it, apps that compete on curation. So, for example, we might have a very secure and tame children's app store. I might want, if I'm going to give an iPhone to an 8-year-old, I might want to take off the existing app store that has literally everything in it and have just a children's app store that was curated by some entity that I trusted. We might have a green app store where to get into it, there's some business model of that store and it has the lowest carbon footprint food delivery, the lowest carbon footprint scooter rental, the lowest carbon footprint bank, whatever it might be, so that I go there first and try to use things in that store and then look elsewhere if I can't find something. I might have stores that specialize in being more secure. So I could have a government app store where I can go and look at transportation, maybe get my food stamps or do my benefits or my student, whatever. And that might be a place where I could put in my postcode and get apps relevant to me or pick a language. I put Belgian here because you might pick Flemish or you might pick French. And that store might have a way to share data that was very secure and match the fact that it was a government site. Or you could have just a very security conscious app store. I think there are options to innovate in the area of payment. One store that I tried to sell a lot in Europe, which went over fairly much like a lead balloon, is the American Express App Store. But this goes over very well with high income people in the United States. Imagine you're a platinum American Express card holder. Wouldn't it be great to have an Amex App Store? Everything in there you'd pay with your American Express card. It would be curate apps for rich people. And those apps that wanted to get into the store would have promotions, and it'd be things like, if you buy using your Amex card, there's a special for tickets to the US Open, and then you get parking and a glass of champagne, and it's all a package for American Express card holders. It would be great. Then you could imagine a newspaper app store where the newspapers got together and actually just made a co-op and said, we're going to run this store together. We're going to charge ourselves cost, let's call it 3%, and sell subscriptions. The Financial Times has not been in the Apple App Store because they don't want to pay 30% of a Financial Times subscription to Apple. So they could join the co-op, pays 3%, which is the cost of running the co-op store, and then you could innovate with things like per article pricing. I'm constantly on social media interested in something. It's an article from the St. Louis Dispatch, and my options are to not read the article or pay $60 for a subscription. I would like the option to pay 30 cents to read the article, and that's not an available option. And if you had a bunch of newspapers, they could get together and make a payment scheme that where the transaction costs were low enough that that made sense. And then, of course, you have app stores that want to do something technologically different, like Epic wants to have the metaverse. Okay. I don't have any opinions about the metaverse, but certainly this is an area we want to open up to innovation. So these are the kinds of explosions of innovation that I think are really worthwhile and could happen through opening up the App Store. And the analogy that I make is, remember Comcast? I used to have Comcast. It cost a fortune. It was a single App Store. It was a bunch of junk in there, and that's like the single App Store we have now. Now I can curate. I can sign up to Netflix, I can sign up to Hulu, I can sign up to BritBox. Some of those things are pay per view, some of them are subscriptions, some of them are ad supported. You can have business model innovation, you have curation innovation. It's all, and that's because we have one wire down which the same video content can be placed. And so I single home on that wire, just like I single home on my phone. As I said, the backup plan is side loading, and the other backup plan is friend. But that's what we might get in app stores. What are the issues unsolved? I think you need to license the app stores. I think they have to pass some kind of check on security and privacy. The gatekeeper has no incentive to do this because they want the app stores to be trashy, insecure, low quality things. Approval of apps themselves. This is currently done by the gatekeeper. I don't think you need to change that. I think app stores can just distribute approved apps. And then the App Store business model, I think curation innovation doesn't pose any hurdles. Payment innovation, likewise, is pretty easy. Technological innovation might require some additional regulation. Like if you're going to do a metaverse, does that involve some aspect of the App Store that is different and impacts the operating system in some way? Okay, contestability and advertising. This is another, I think, big area where the DMA could make a difference. So as I said before here, this is just information, but this is important. This is banning data combinations without user explicit consent, requiring data to be held in silos unless users give explicit consent, giving users the right to real-time data portability. That's not just I take it once and go, but I have an ongoing ability to move my data from one core platform service out. And for the business users, the ability to have their data, some of which is generated by users who have to give permission, continuously move that out. And that has fairly big repercussions. So the personal data, for example, would be queries I enter in Google search, products I search at places I go in Google Maps, products I search for and buy on the Amazon Marketplace. Now imagine what could happen if my video subscription that costs 10 euros a month could have access to to my Google search and my Amazon purchases. Now they feed that into some ad tech stack and design ads for me that are much more valuable than they were before. They have ability to design ads similar to the ads that Google is designing. Then maybe my video subscription can have ads in it that are valuable and cost me less money. That might not be something everybody wants, but that might be something that a segment of the population is quite happy to have, an ad-supported service where the ads are valuable. So think of a regular telco in Belgium again. They can offer a lower price subscription to a user that agrees to share their personal data. Okay, you need proper consent so that user isn't being exploited in any way. They're choosing this on purpose. And importantly, you don't have to worry so much about bots or fake accounts that are trying to get a subsidy, because if I'm the telco or the AT&T provider of this phone, I can authenticate that user. I know that I'm dealing with a real person. So this allows rival ad-supported businesses to get similar data to Google and Meta and compete for advertisers' business in a more robust way. And also because of the analytics and the DMA, you then have the ability to demonstrate how good your ads are because you can compare them with the tools to the Google and Meta and Amazon ads. Okay, what are the issues here? Markets for data are controversial in Europe. The personal data is a fundamental right. Okay, that's true, but yet, even though it's a fundamental right, personal data business models are thriving and all over the place, and everyone's being exploited just the same way they are here. So I think it's a bit too late to stop it. Many, many businesses have been established, and it would take a very brave court to just say, we're going to shut down the internet because it's ad supported. But currently, consumers have no ability to control how much data they share, nor to get a reward from sharing more. And the Digital Markets Act and the Digital Services Act and the Data Act and the Data Governance Act open up the possibility that we could go down that path. But we would need much more market infrastructure to make this work. So this is a little tricky, but I will say these telcos are quite aware that this is what they want to do. They want to get that data and they want to use it. Okay, contestability and search. This one is hard. So how is contestability and search going to come about? Well, first of all, we're going to have fair rankings so that the vertical search engines can be in the list in the proper place. We're going to have friend access to click and query data of the Google search engine, and we're going to have uninstallation and abilities, default choices, and choice screens that are properly designed. And we're going to have limits on tying between core platform services. So we've got a core platform service of Google Android, core platform service of Chrome, and a core platform service of Google Search. And those things cannot be all tied to each other. Okay, we're going to have choice screens that get inserted as we go along. I think contestability in search is the hardest, and it's not clear to me we're going to see change. On the other hand, you have to set up the conditions for change and then wait for the shock. So in other words, we have a choice screen is necessary but not sufficient, because why does the user choose Google now? Well, it's the best. Why is it the best? Because everybody's using it. Why are they using it? Because it's the default. Why is it default? Because Google can tie. So if you break that cycle and you say, well, there's a choice screen and everybody's allowed to do what they want, maybe today people choose Google, but maybe some of them choose something that plants trees and other ones choose something that's more private. And those are niche choices. But then along comes an artificially intelligent search engine that is really better in some way. Now that in the old days, that thing couldn't get onto your handset because you were defaulted into the Google product. Now it can be in the choice screen. So the door's open, somebody can walk through the door. If you have the door closed with the default and Google in charge of everything, no venture capitalist is going to invent the search engine to walk through the door because the door's closed. It can't get any customers. Once the door's open, you have the possibility of the investors investing in an entrepreneur that's planning to walk through the door. So it's not going to be an instant process. And these technological shocks are rare. So perhaps AI is a moment for entry. I will say right now, I read in the newspaper that Google is in the process of negotiating with Apple to pay to put its AI search engine as the exclusive default on the iPhone again. So it's John needs to fix that problem. But let's amend the complaint and go back and say, wait a minute, if we're going to have a monopolization complaint, how about you don't, while you're in litigation, monopolize the next round of technology? Okay, the traffic or default providers can sponsor entry, and so we need to enable them to do that. And the traffic providers used to be portals and so on, now it's browsers. The fundamental problem is the business model, which is the origin of Android was this barter idea. I give you a mobile operating system, OEM, in exchange for the ad revenue that your handset generates with the people on it. And that was the plan. I give you all the software, you give me the ad revenue. That became a very unbalanced transaction where the software wasn't worth very much relative to the amount of ad revenue. And so when you regulate, you change the terms of that barter. And that thinking about how much we change the terms of that barter and who would come in. Like, would it be Samsung that decides, okay, now I'm going to come in. I'm going to contract with Bing to be the default, which I'm allowed to do because that's not a core platform service. And people can actively go and install Google if they want. But in the meanwhile, I know I'll get a whole chunk of them using Bing. That means Bing will get much better. That means Bing then puts competitive pressure on Google, and we go around this virtuous circle. But it's not clear that Samsung is going to do that, as opposed to have a nice relationship with Google where they share the monopoly profit. Okay. A feature of this law that I think makes it intrinsically difficult to enforce is the chicken and egg problem. So what do I mean by that? Compliance is defined by whether it's effective. What is effective compliance? It's not really known by the regulator because of this asymmetric information problem. It's really defined by the business user. Compliance is effective if it increases contestability, I can get in, and fairness, I get more rent. I'm the business user. So it's really the business user that understands whether compliance is effective, and the business users who are going to have to figure out if they can enter and carry out their business model. They're going to have a business model. They're going to have to document and go to the commission and explain why they can't carry out their business model because the platform is not doing it right. And what you need for that is an active business user, a business user that has a plan, has a business model, wants to innovate, is trying the interface, finds it has flaws, and goes and tells the commission. And that, a lot of them, I discovered last fall, are hanging back, waiting for the commission to deliver them a perfect interface. And that is not going to work because then the commission has to, like the platform says, we made one. Here's our report on why it's in compliance. And there's going to be no reason for the commission to question that. So for the interface to be effective, we need a business user. But for the business users to exist, we need an interface or there is no activity for them to be doing. So if Europe wants to claim that it is a continent that has innovation, okay, they don't have the big digital platforms, which I think is actually fine. I mean, big digital platforms come with big problems. They move fast and break things, and the things that they break are largely American things. So that's, in some sense, you want the digital platforms to start in America and have all the labor problems and the women freezing their eggs and the lack of democracy and so on happening here, and then regulate in Europe. But you don't want to give up the business user innovation, I think. And the business user innovation, if the Europeans can't come up with it, then they're not going to be able to make this regulatory scheme work. So we need business users in Europe. Now, it's possible that you've got some business users in the United States, like Epic, who see that the way to go is to go to Europe, set up an app store, make it marvelous, and then make everybody in the United States jealous. So the most common question I got in Brussels last semester was, what's going to happen in the United States? And my answer to that was largely, well, it depends on how successful the DMA is. Because if the banks all come in with digital wallets and there's cool fintech and the fancy law firms in New York go to a conference and their partners are doing cool fintech stuff and they can't because their iPhone doesn't have any competition in digital wallets. And their cousin in Italy has the children's app store and they don't because Apple won't allow in rival app stores. That makes people upset. Then they say, wait a minute, I'm American. I'm like, it's a given that I live in an innovative place. And then, moreover, the banks go to their senator and they say, we want digital wallets. And we live in a country where banks tend to get what they want. And so if you've got enough of the business users lobbying for these things, that's most of GDP. And the business users have more corporate profit in total than Apple does. And if your model of governance in the United States is he who has the most corporate profit gets the law he wants, then that would get us some either regulation, or forestalling the regulation would be Apple and Google simply deciding to roll out their app stores globally, which they might prefer to trying to have two sets of trying to satisfy multiple sets of regulation. It might be easier to roll it out and then try to forestall the regulation in the United States. So big tech came out swinging. Enforcement is not going to be a walk in the park. Big tech came out swinging on the 7th of March. Apple's App Store rules are a per user, basically a per user fee, 50 cents per year, for any developer who distributes outside the Apple App Store. So if you were Santander Bank or Deutsche Telekom or an airline in Europe and you wanted to distribute your app store through a rival app, through Apple and somebody else, you would immediately have to pay 50 cents per download on everybody. Okay, so if you had 100 million users, you would be owing Apple 50 million euros a year if you had 2 downloads in the rival store. Okay, so what this does is it's a tax on using the rival store. So it means that the 99% of apps that don't pay anything in the Apple model will all stay in the Apple store and they will refuse to use third-party stores. So the third-party stores cannot get off the ground as normal stores. They can get off the ground as pornography, as gaming, as slightly sketchy things that Apple won't let into its own app store. And that, I think, is how Apple's going to try to make this work. That the third-party app stores are lowbrow stuff that nobody really should want because they're not secure. They have things like pornography on them, and they don't have any apps that you would, like American Airlines, that you would normally want to be using. So that's, and also the rules, at least initially, there's been a modification, said that the only kind of third-party app stores must accept a wide range of third-party apps. So that you couldn't have, say, Microsoft or Epic wanting its own app store that just had Microsoft stuff in it or just had Epic stuff in it. That was ruled out. I really don't think that the incumbent core platform service should be allowed to direct the business choices of the rival app store. I think that's a red flag right away. And no plans for authorizing these third-party app stores. So that's really terrible. And Google Store, I have not looked at the rules on Google Store yet, so I'm not sure what to say about that. The other thing that happened in the fall and is mostly about GDPR, but is covered somewhat because of the DMA's duplication of GDPR, is that Meta was required to improve the privacy. Right now, um, the default offer in Meta tracks you all around the internet and costs you no money. And the court said, well, that's not compliant with GDPR. There's not enough privacy there. You're tracking personal data without people's consent, and consent has to be, they can tick a radio button, but consent now means a real thing. Like you have to go actually educate people and ask them properly. And you're not doing that. So since you can't claim consent anymore, you're taking personal data in violation of the rule. So what did Meta do? Meta brought out a subscription model. You can pay to be on Facebook. That was 10 euros a month, and then they lowered it to 4 after outcry. But this subscription model just gets rid of the ads. It does not actually stop tracking you. It tracks you just as much as it did before. It just doesn't use the information to show you ads. So it's not any different in its privacy implications. So these are platforms that are not compliant. And it took the commission, happily, I have to say, only about a week to announce the start of non-compliance proceedings against Google and Apple over the stores and against Meta in terms of their privacy. But there'll be a lot of other non-compliance problems, just not ones that are so glaringly obvious that you can announce proceedings that fast. So we'll see what the next steps are on both sides. I think I won't spend much time on more competition enforcement, just to say entrenchment theories of harm are needed. We have those in the new merger guidelines in the United States. We need more work on potential and nascent competitors. We need more work on not making market definition be a barrier to enforcement when we have these very plastic products like software. And we need to be very, very clear that our harm in these digital markets is not usually a percent increase in price. It's something about innovation and entry. Um, and that consumers are not neoclassical consumers, they're behavioral consumers, and network effects are just so giant that we need to assume market power much more readily than we have. So there's a bunch of stuff to do there, and there's a bunch of stuff to do on consumer protection. You really, because of the entrenchments of market power and the behavioral consumers, we cannot rely on consumers to do a good job. They're going to make mistakes, particularly when they're just the endless ability of platforms to A/B test and exploit them. So if the offer from the firm is hard to understand, like how much am I going to use your data for ads? What is this financial service that I'm offering you? All the different media subscriptions, which one do you want? And let me describe each one and and frame them the way that I want so that you choose the one that's profitable for the platform. Those kinds of things mean that we really are going to have to do much more consumer protection and be much more paternalistic. It's not, I wouldn't say it's really paternalistic because consumers are making mistakes. You need to get them to the same place we are in the market for bread, where the consumer is enabled to make choices and then can evaluate quality and is protected from poisonous products. And that's a big issue. So there's a lot to do. It's an exciting time for Europe. It's exciting time for anyone interested in competition law and economics. And thanks for your attention, and we can have questions. Yeah, sure. Questions. Yeah.
Just wait for the mic.
Mm-hmm.
Hello, thank you so much for doing this and being here today. It's so fascinating, the things that you're doing with the DMA. When you say data silo, who has access to the data silo, and do any government entities have access to a data silo?
No, what that means is if you are a platform with multiple businesses, let's say Google, the personal information that you get from Gmail cannot be automatically combined with the personal information from search and the personal information from map. Those are different core platform services, and the data cannot be combined across them without explicit consent from the user.
Thank you.
Just curious your thoughts on the role of sort of venture capitalists. So you talked a lot about creating incentives to fund people to walk through the door, the chicken and egg problem. But again, venture capitalists would have a voice, right? Their experts would be looking at this, and whether or not they'd at least have some expertise. Is that good enough that I would fund? Is that, well, what do we see them saying so far? And is that a good source of information?
It is a good source of information. I don't know what we're seeing them fund yet. I have a student who's doing media searches and scraping to look for names, in particular in the area of digital wallets and app stores, because those are the big areas where we know there's pent-up demand. Hopefully in a month, I will know a bit more, but I should go and try to find some human beings to talk to about that in Europe, but I haven't done that yet.
So I don't want to let the perfect be the enemy of the good enough, but I was intrigued by your thoughts about gatekeepers being defined by size, and there are certainly some advantages of that, and maybe we think of this as the initial foray. But I wonder whether you worry, given your emphasis on we have to be forward-looking, that we're sort of regulating the problematic companies now, but we're missing or we're not preventing kind of other problematic companies from creating situations where we have future gatekeepers with problems.
Yes, the DMA has the ability to designate core platform services that do not meet the size threshold if they have sufficient other problems like market power and so forth. So there's a path to get there. There's also a path to amending the law and deciding you want a different definition of a business user or a different size or something like that. My initial fear when this law was first released was that the commission would try to regulate 25 gatekeepers in the first bite, so to speak, and that would be a disaster. So I was just relieved that it was these ones, because I feel like we have a good social understanding and economic literature pointing us to what the harms are here. And it's much less clear what the harms are from SAP or Booking or whoever it might be. So it seems more difficult to get your regulations to always be increasing social welfare with as you go down the platform size. So, long way of saying, I don't know how to handle the problem going forward, but certainly maybe we should learn from what we're doing now and use that to guide what we do next.
So I'm going to take the prerogative of
being the organizer.
Um,
do.
so what I struggle with is trying to figure out, kind of given that these companies are global companies, but you have regulatory structures that are by geography,
Yep.
and how these geographic regulatory structures are going to rationalize. And so it seems to me the DMA is very much an ex ante approach to trying to kind of stimulate competition and innovation. The US is very much ex post judicial, kind of after the fact if there's an issue. And I can imagine a world where there are complements, and I can imagine a world where there are substitutes in competing, and there could be a first mover advantage, for example, for the EU in getting regulations out and setting the process. I know that there's the US, EU, US Trade and Technology Councils meeting like today and tomorrow. Do you think these things are going to rationalize, or how do you see that
Yeah.
playing out?
It's a really good question. If you run one of these platforms, what's the right response to regulation in Europe? Do you want to just roll it out globally? Do you want to have an exploitative model in the United States and a competitive model in Europe? How quickly do Australia, New Zealand, and Canada say we want the European one, which I think might be fairly prompt. I mean, certainly it's easy, right? Free ride, say we want the same version. Or we watch carefully, we see this enforcement thing that you're trying to evade, and we just say we want the same one. Plus, we're going to close off, it's a whack-a-mole problem. We're going to close off a few of those holes in here in Australia or whatever. I would not say that the US has a solution that's a judicial model. Our model is just antitrust laws. This goes far beyond that. It goes to competition on the platform, which our antitrust laws can't do. So we don't have anything that's competition and barely a complement really either. I think the easiest way to describe the US is nothing. Nothing is happening. Um, but we pay attention. I mean, I really do. I'm quite serious about banks and digital wallets. I mean, that fintech has taken off in the UK because of open banking, and people can do cool things. And if cool things arise in Europe, that's going to become a position that is not tenable for. I mean, I got my first call from an attorney who has a lot of banking clients who said, "What's going on? Why can't my clients have this cool, shiny thing?" And I said, "Well, it's because they live in the United States where we don't do anything." And he was upset on behalf of his clients. So we need if that's if that's an emotion that takes off, then I think something's going to happen. I just don't quite know whether if you're Apple and Google and Meta, you prefer to forestall regulation in the US by rolling out the European model, or whether you think you can control regulation in the United States enough that you make a more moderate, less costly version in the United States and lobby for that.
John may want to comment on nothing happening in the US. I'm just
No, on antitrust things are happening, but not on this other stuff.
teasing.
Yep. On the chicken and egg problem, you volunteered that you want a business user to tee up to the commission so it's resolved. Any experience with the retaliation that might be occurring when the business user brings forward?
Yes, exactly. So the business users who go to the commission, then of course there's some kind of appropriate open records. You have to be allowed to rebut the complaints against you, due process stuff. And so those business users are very hard to protect. And you can maybe say they can't be retaliated against in Europe, but what if they're retaliated against in the United States? So business users are quite apprehensive about speaking up. There's straight up complaining, and then there's just even the idea of having an idea. So bringing forward, here's the thing we'd like to build. I think we all understand what a rival app store could be, what a digital wallet could be, but presumably there are many ideas out there that I can't communicate to you because I have no idea what they are or what they might be. And even just articulating, we'd like to build this, even without complaining against anybody, just saying, here's the thing we want to give to consumers, would be useful.
I do understand that this is a bit of reading the tea leaves, but do you have any feeling of how this will impact the European startup market and generally like if this will lead to innovation in Europe compared to the US? And yeah.
I don't know. I think in an ideal world, it does. I think that's what the more progressive what the more progressive sponsors of this legislation want to have happen, that you've got startups doing things that are legal in Europe and not legal in other jurisdictions, setting up shop in Paris and being all innovative. Um, and I don't see why not. I think startups in Europe are quite common. Apparently, the problem is growing from small to medium. That the medium, you really need an internal market to have scale, and the internal market is not as good as it should be.
Yeah.
Sorry, you've had your hand a few times. Do you have the microphone? Okay. Yes, here, there's a mic.
Thank you very much. I'm Tila. I'm an MP1 here at the Kennedy School, and I have two questions. One is on the Data Act you briefly mentioned. What do you think is the potential of the Data Act and the right to data access in combination with the DMA? Will it actually enable new companies to do something comparable or be part of this ecosystem? And my second question refers to the wallets. They have not been designated a platform service so far, in my understanding, but I figure that they can be quite powerful tools in business. What is your perception of both the potential and the detriment wallets can do, also related to digital identities? If, for example, as in the US, government identities will be part of a wallet in the future.
It seems to me that a sensible thing that a government could do would be to use the power to enter with a digital wallet to say, let's let you have an identity that is offered by the government. I think Estonia does this, so that your identity is not controlled by a platform, by a private party that can hold you up or hold up anybody. Digital wallets are explicitly in the law, in that Apple is required to have the NFC chip is one of the things that has to be opened, and therefore that allows competing digital wallets to exist. So that's the sense in which they're in the DMA, and banks are very keen on that. Your first question, Data Act. I am not a specialist on the Data Act. I have too many acts that I'm trying to keep track of. But one thing that the Data Act does do is allow for intermediaries, data intermediaries, to serve consumers. I think that's extremely important legally, because any of these data markets, each transaction is going to be worth very little. So if you don't have somebody aggregating them, then you have transaction cost problems. Moreover, I don't want to be doing what I'm doing now, which is clicking yes, I agree on every website. I want to have an agent who acts on my behalf, who says yes when I've said yes and no when I've said no, and agrees to share not my location, but yes, that I am shopping for shoes, whatever it is that I've selected. I want that to be applied to all of my interactions, and then I want benefit to flow to me from that. And I think you need an intermediary.
You mentioned in passing approved apps, if that might come from another app store.
Yeah.
I'm somewhat concerned about the security, not only of the particular user who might want to take that app and take whatever risks he might face, but how it could populate onto other phones or pads or systems into which he interacts. And it's not a cheap or simple process to approve an app and to check it for security, and also to keep it that way if it's being worked on through another store, and changes might be made even after the approval.
Yes, and that's why I think the very simple way to allow these app stores is not to change anything about that. I mean, currently Apple claims to review apps for security and privacy and charges money for it, and maintains it over time, as you say. Google claims the same thing, although they don't use humans, they just use automated tools for reviewing apps. So all you have to do is say third-party app stores have to distribute authorized apps. And then we're just in a business of being in the same, we have the same level of security and privacy we have today. Oh, they're right now it's you pay, I mean you pay $99 to have the software development kit. So effectively it's a $99 fee. I think it would be fine if the platform wanted to charge some kind of cost-based fee. If it costs, I don't know, $250 to approve an app, then charge app developers $250. That seems fine. So you might have to regulate that fee, I suppose, if the platform decided to charge $1 million or something. But I think broadly speaking, just keep it the way it is now. It's not broken. Don't fix it. And then you see the App Store becomes, it's like I described Comcast. The video product is not different. Game of Thrones doesn't matter whether I get it through Hulu or BritBox or what, it's the same program. But the distribution can differ on business model, on price, on curation, that kind of thing.
I wonder if you see any sign that China is responding to the incentive dimensions of this act. Is it shaping China's behavior?
No, they seem to be a self-contained economy all to themselves with they have super apps. I mean, you're on WeChat and you don't care what your underlying operating system is. That's why I think one of the reasons why Apple has a lower share in China and many app stores, and it's a whole different world.
But they have three major presences in the United States: Temu, Shein, and TikTok. Will they not respond in some way?
I think they just have to comply. I mean, I don't know anything special about that.
Do you have time for one more question?
Fine.
I have the privilege.
Okay.
So I don't know the extent of the problem, but I'm imagining that for a lot of the executives at big techs, they also sit on the boards of business users, companies. I think there's a conflict of interest there where they might be less willing to promote the kind of activity to contest the market power of these core platforms. So I'm curious about whether there are restrictions on these kind of interlocking board seats in these cases.
I don't know. I mean, certainly if you're the shareholders of the business user, you want it to maximize profit, not to be controlled by the platform. So probably those people shouldn't be directors if they're there. I don't know if there's a rule. Sorry.